2, 1. Go.
Earl, wala ka lang sound.
Evening, everyone, and welcome to the special learning event on how to prepare your last will and testament. Before we begin, we would like to invite you to join us in a minute of prayer.
Lord, make me an instrument of your peace. Where there is hatred, let me sow love. Where there is injury, pardon. Where there is doubt, faith. Where there is despair, hope. Where there is darkness, light. And where there is sadness, joy. O Divine Master, grant that I may not so much seek to be consoled as to console, to be understood as to understand, to be loved as to love. For it is in giving that we receive. It is in pardoning that we are pardoned. And it's in dying that we are born to eternal life. Amen.
Again, a pleasant good evening to all of you. And my name is Richard Mamuyak, and I'm from the Asian Institute of Human Resource Management, and that's the training arm of PMAP. And on behalf of our PMAP President Lynn Muki and Executive Director Rene Henner, we'd like to welcome you in this special learning event on how to prepare your last will and testament. For sure, some of you is having an evening that is not the usual, because you should be watching the news now, or at least watching a movie by Netflix. But I can guarantee you that in the next few hours that you'll be spending in this webinar, you'll definitely learn some information or teaching that you can apply in our lives. It may sound morbid, but the topic is the reality that we need to accept, that that is something we cannot escape. So basically, and it's not something that we plan to do in the nighttime. It's just that we want to try doing a webinar when everyone is at home and trying to relax. Okay, so before we begin, I just want to check or do a survey. I want to know where are you watching this webinar right now? So can you type in your location just to make sure that all of you is has the capability to chat, because in a while we'll have interaction with our speaker. I can see someone type Iloilo City. Wow. Valenzuela, Quezon City, Pasig. Wow. I'm from Pasig, by the way, so nice to see a fellow Pasigueño watching this webinar. Quezon City, Tanawan City in Batangas. Wow. So basically, we can see participants coming from different parts of the country. I just don't know if we have an attendee or some attendees watching overseas, but for sure, since this is being played live via YouTube through the official PMAP Facebook page, definitely we can reach people even overseas. All right. So in a while, I'll be introducing our speaker, but just some reminders in case you have some questions already in mind while the presentation is being discussed. You just type it in, and we'll be gathering those questions, because we'll be having a Q&A at the end of the presentation, and you'll also get a chance to be put on a spotlight. You'll have a video and audio functionality during the Q&A, so you can talk one-on-one with our speaker. Okay, someone is watching this from Cavite. Good evening there. Okay, so just keep on timing in. Someone from Bicol is watching here as well. Okay, so I think this is the time for me to introduce our speaker. And of course, he's not new to PMAP, and I'm sure you are familiar with our speaker. Let me just adjust my screen. Okay, our speaker is the former Undersecretary of the Department of Labor and Employment, and also former diplomat and labor attaché to three countries, Malaysia, Kuwait, and Taiwan. Aside from this, he is a former top HR corporate executive of San Miguel Corporation, Pepsi-Cola, and Petron. And right now, he is also a law professor, bar reviewer, and author of many books on human resource and labor law. He's also a well-recognized ASEAN expert and lecturer on comparative labor laws and a council of ECOP Calabarzon and Region 4A chapter. Aside from this, he also does consultancy work for various global and national companies in banking, business, food and beverage, cement, hotel, packaging, oil shipping, transport, and education. And of course, one of our favorite lecturer on labor law. Ladies and gentlemen, kindly give a warm virtual round of applause to our speaker for tonight's webinar, the 2014 PMAP National President, Attorney Josephus B. Jimenez, DPM. Good evening, Attorney JBJ.
Good evening. Can you allow me to share my screen?
Definitely, sir. You have that capability.
Magandang gabi sa ating lahat. There were more than 150 who registered, and there are only less than 70 in the room right now. So we are waiting for a lot of people to come, but we cannot defer the start of our presentation. We have to do it immediately because we have a long topic to tackle tonight. Can you see my presentation?
Yes, Attorney JBJ. Very clear.
Okay. How many people are now in the room?
Attorney JBJ, they're adding up. So right now it's 59. So I'll check how many are watching by Facebook. Of course, we have bigger reach or wider reach with the social media. And we'll definitely share it to our different groups as well.
Okay, so I was furnished a copy of those who registered, and I found out that many of our friends are coming. We have the President of Manila Broadcasting Corporation, Mr. June Nicdao. This lady is very familiar to PMAP, Ms. Flor Glenoga, President of Altabest. We have the President of Global Processing, Magsaysay Group, Eric Nelson. We have Celia Guzman, a member of PMAP, an active member, President of Yearning Outsourcing. Ferdinand de la Cruz, CEO of Franklin Baker. And I have my student in the University of Asia and Pacific, Ms. Cas Salud, a Japanese who married a Filipino. We have Attorney Giovanni Belgar, member of Palscon and chairman of the Wizard Manpower. Of course, we know Leo Hilor, Executive Director of Upskill, and Dr. Sol Amer of Xavier University, HR Director of Xavier University and former President of PMAP Cagayan de Oro Chapter. Dr. Wilfred Tew of Trinity University of Asia, President. Cecil, of course, is a very active PMAP member, is VP of Malayan Insurance. Hilda Cardenas, a member of the Board of Directors of PMAP currently, like Ning Adolfo also. country HR head of Merck. And Attorney Garni Alegre, my student in University of Asia and Pacific, like Ye Bautista of St. Peter's Life, and Hans Cobilla, also my student, director of Sky Cable. We have Leah Morado, my friend from Pepsi Cola, and that is reputation. This is now the 4th session that I have conducted. I have done this a number of times with longer time allocation. Tonight we have barely 2 hours, and then we must have 1 hour of question and answer. So to those who are with us tonight, you don't have to record this, because if you subscribe to my YouTube channel, you can get a copy of the video. If you follow me in the Facebook or subscribe to my YouTube channel, you will get 39 plus 1 tonight. 40 videos about HR and related topics. I'm also in the Twitter. So why am I doing this? I'm doing this because this is my ikigai. My ikigai is my way of service to you. Because the COVID statistics are quite alarming. No, I did not update it as of September. We have already in the Philippines 2.4 million. As of today, it's already 2.8 infected. Although the rate is going down, but it is still alarming. The Philippines has one of the highest death per 1 million. 336 Filipinos for every 1 million died. And the rate of vaccination is not very encouraging. Region 3, the central plain of Luzon, has the most number of unvaccinated senior citizens. Unvaccinated. So I'm not trying to scare you, but we are number 19 in the whole world in terms of number of infection and rate of mortality. Number 19. There are about 200 countries in the whole world, and we are number 19 when it comes to COVID infection. Of course, Indonesia is higher than us, but we are much higher than Malaysia, Singapore, Thailand, and Vietnam. So these are very disturbing figures. And among the 17 regions in the Philippines, 12 regions are considered as high risk. And Metro Manila is one of them. Metro Manila is a high-risk region. And 6 of the 8 regions in Luzon are considered high-risk areas. 5 of the 6 regions of Mindanao are high-risk. Better are the islands in the Visayas now. As of today, we are no longer high-risk. Central Visayas, where I come from, Cebu, is not very problematic nowadays. The response was very effective in our region. The only region in the Visayas which is a high-risk region is Western Visayas. No? Western Visayas. So I'm doing this because based on the life expectancy rate among Filipinos is, as you can see on the screen, is 68.8 for the males and 74.3. So every female is expected to live up to 74 years old, average. And the males die early. The males die earlier, 68 years old. Now, I'm already 72 years old, so I am beyond my time already. Among the people in the world, the highest expectancy rate, life expectancy, is in Japan. The best place to be living is in Japan. Maybe it's in the lifestyle or in nutrition, or it is the ambience or the environment. The culture of the people are contributory factors to high life expectancy. But the Philippines is lower than China, but higher than India. We are higher than Russia and other countries. No? Can you imagine Israel, which is surrounded by its enemies, have expectancy rate of about 80 years old, while Filipinos only an average between males and females 71 years old only. So if we follow this pattern, those who are in their 60s today, we have 10 years to live. And to those who are in their 70s, we are supposed to be in the pre-departure area already, pre-departure area. So having declared all this, I am trying to help. But remember, ladies and gentlemen, that the number one killer in the Philippines is not COVID. The number one killer here is heart disease, breast cancer, cerebrovascular disease, pneumonia, diabetes mellitus, hypertension, tuberculosis, other kinds of cancer. Or if you do not die of this, you may die out of extrajudicial killing, traffic accident, or natural calamities. So there are many reasons to die in the Philippines. There are many driving factors. Dying is being driven by so many contributory factors. So some people die also worrying about the pandemic, worrying about money, worrying about family conflicts, worrying about failures in love, and too much Korean drama is also harmful to your health. Carrying our sinfulness and our malignant sense of guilt is hazardous to our health. We carry a lot of anger. We are not able to manage our emotions. That's why the mental health during the pandemic is quite problematic. And we have a lot of regrets and guilt feelings. So all this will contribute to the hastening of our end. So if you read the Bible in the Revelation, you will come to know of the 4 horsemen of the apocalypse. One represents wars, the other is disasters, the third is pestilence, and that is where pandemic, health crisis, COVID, pestilence, number 3. And then after that, food hunger, food insecurity, in the light of so many factors bringing about dangers to our food security. So death comes like a thief in the night. According to St. Matthew, we have to stay awake, for our time is coming and we do not know the exact hour. No? So we have to be ready. And what we should prepare? No? We should prepare our soul to meet our Creator. Let us prepare our burial place. We have already purchased burial place in Manila Memorial, as well as for the columbarium in case we want to be cremated. And also the last one, and we will discuss this tonight, is to prepare our properties and documents. Prepare our properties and documents. Because even if we are not very rich, we are not like the Taipans or the Taikons or the magnates. We have certain personal positions. We have, for instance, jewelry and wardrobe, and books, mementos, your certificates. You do not want your children to throw away all these things. That's why I have already made a last will and testament, and I am giving a piece of land to one of my children on the condition that she will construct a small memorial in our town in Cebu. JBJ Memorial, where all my books, all my trophies, all my plaques of appreciation will be put there to inspire the young people in our small town in southwestern of Cebu, 82 kilometers from Cebu City, going to the south, facing the island of Negros. So that is my instruction, that I give the piece of land on the condition that there is going to be a place for all these things. These are important things to me. If you have cars, equipments, machineries, you have furnitures, you have antiques, even family albums, musical instruments, guitars, you want specific people to be having that after you are gone. Paintings, if you have very expensive paintings, and documents, your religious articles when you visited the Holy Land or Israel or in Vatican, you have purchased some very important relics. You can put that in your last will and testament. Without a will, your heirs may just throw away those precious legacies that you left behind. And it's a pity because you work hard for them. Children of people are known to be bickering and having conflicts because the father of their or the mother were gone without having specified what to do with the property. So regardless of amount and value, relationships are damaged and destroyed because the owner, the original owner, was not able to specify how to divide, how to distribute, which one will go to whom, and under what condition. And all this, of course, are not intended by you, but you want to be your children to be at peace with each other when you are gone. So we do not want to repeat the intense rivalries between brothers, like the rivalry between the child of Sarah and the child of Hagar in the Old Testament, the quarrel between Ismael and Isaac in the tent of Abraham. So all this, I do not want to spend much time because we lack. I have prepared a lot of slides. I even have history about the 12 tribes of Israel, the 12 children of Jacob, which are causing the conflict now in Israel and in Palestine because the properties were not properly divided by the parents. So I just want to emphasize that principle, and I want to begin this presentation now with, of course, your names are listed here, but many have registered, but only few have come. No, I have very special friends here in PMAP, in my teachings, in Pepsi Cola, like Leah Morado, Pepsi Cola, and Jocelyn Amado will come, no, to this presentation. I hope that you can have this in Pepsi Cola to help your line managers. So we will start now with the following basic principles. We want to start with principles. Richard, how many people now are inside the room?
Sir, meron na po tayong 59.
Okay. Malayo yan sa nilista ninyo.
Actually, we have 68 people here now.
Okay. Yung 68 people na yan, mga 60 from PMAP. 8 lang yung bisita natin, no?
But we have already 20 plus in Facebook now watching. So,
Okay.
mamaya po mag-pick up yan.
So, number one principle. The law, the Civil Code of the Philippines, particularly Book 2, the law on properties. You know, the Civil Code of the Philippines have 4 books. Book 1 is about family, persons and family relations. Book 2 is property. Book 3 is inheritance, succession. That is the topic for tonight. And Book 4 is obligation and contracts. Lahat ng contract, nandoon ang sale, nandoon ang partnership, agency. So, in the law of property, when you own a property, the law gives you the freedom, no, to control how your property will be divided even after your death. That is if you choose to execute a will. When you choose to execute a will, that is called testate. So the succession, the inheritance will be called testamentary because you have a testament, testate, no? But if you do not want to control beyond your death, bahala na ang batas, then the law will distribute your properties. That is called intestate. Intestate. So a person who dies without a will have intestate succession. It is the law that will determine how your property will be divided. And sometimes the children do not follow the law. They want their own way, which may be in conflict with the desire of the other siblings. So that will cause conflict in the family. But if you have outlined your desire, your will, no, you know that the key word is your will. Your intention, your decision should be honored by your ears. So, number 2, you don't want to interfere. Let the law takes its course. That is where more problem will arise. Number 3, if you choose to take control over the distribution of your properties, such prerogative is still subject to some limitations. For instance, if you have 100 million pesos, you cannot give away all the 100 million to other people because the law reserves at least 1/2 of your entire properties to your compulsory heirs. So I will enumerate who are your compulsory heirs. Na they are really entitled. You cannot squander your wealth in such a way that you give away 1/2. You give away everything without reserving at least 1/2 of your properties to your compulsory heirs. Number 4, Whether you choose to control, and that is testate, or you choose not to control, that is intestate, the law always mandates that one half of your properties, and that is called legitim. So one half of your properties is called legitim, cannot be given away except to your compulsory heirs. No? Next, the compulsory heirs means your children, because succession goes down first before it goes up. In other words, if you die and the only relatives who are left behind are your children and your parents cannot inherit anything because you have children. So the love and the inheritance is like a river. It goes down first before it goes up. Your parents can only inherit if you have no children. Now, if you have no children, if your children are all legitimate, your parents cannot inherit. But if you have an illegitimate child, one half will go to the illegitimate child and one half will go to your parent. So the illegitimate child has a lesser right than a legitimate child. Your collateral relatives. Who are your collateral relatives? Your brothers and sisters cannot inherit from you if you have a parent. The parent will inherit, but not the brothers and sisters. Because your relationship to your brother is 2 degrees, but your relationship to your father is 1 degree. If you draw a line between you and your father, that is 1 degree. 1 line, 1 degree. No, that is a vertical line between you and your father. That is 1 degree. Now, how many degrees are you related to your brother? 2 degrees, because you have to go up first to your father, then you go down another line. That is 2 degrees. So if you have a first degree cousin, you are related to your first degree cousin by 4 degrees. 4 degrees. No? The first degree is between you and your father. And then the second degree is between your father and your grandfather. Then from your grandfather to your uncle, that is the 3rd degree. Then from your uncle to your cousin, the daughter of your uncle, that is 4 degrees. So your first degree cousin is really 4 degrees. You cannot get married with your first degree cousin because you are related by 4 degrees. But if your cousin has a daughter, you can get married with the daughter of your first degree cousin because she is already 5 degrees related to you. The law prohibits only marriage within the 4th degree of consanguinity. I'm just trying to share with you how to count the degrees. No? Huwag ninyong paniwalaan yung salita natin na 2nd degree cousin, 3rd degree, because pagka 2nd degree, that is already 6 degrees relation. No? Because the degree will have to go first to the common ancestor before it will go down. And then there will be a repeat of the counting. So instead, when you say first degree cousin, that is 4th degree. Okay? So the collateral will not inherit. The uncles and the aunts, the nephews and the nieces and the cousins will not inherit from you. If you have a direct descending or direct ascending, when you say direct descending, it's your children or your grandchildren that is descending. Now, if you have no children, you have no grandchildren, you have a father or you have no more father, but you have a grandfather. Your grandfather can inherit from you, no? But not your brother or your sister. Your brother and your sister will not inherit because you have a grandfather. Your ascending line still exists. No? So the brother and the sister is collateral relative. The uncles and the aunts are collateral. They will not inherit if you have a descendant or an ascendant. Okay? Number 7. If you want to write your will and testament, you can give away to anybody, even to a stranger. You can give away 1/2 of your properties even to your parish church, to your Red Cross, to PMAP. You can donate to Richard Mamuyak or to Ishe or to Carol. No? If you have properties, you can give to anybody, but limited only to 1/2. No? Now, before your property can be divided, your conjugal partnership should be liquidated. In other words, if Juan and Maria are married to each other and Maria dies, Juan cannot distribute the entire property because that is conjugal. No? Conjugal meaning if the husband and the wife have 100 million pesos, 50 million belongs to the person who died and 50 million belongs to the surviving spouse. Now, since he died already, the wife already died, that 50 million can now be inherited by the heirs. Who are the heirs of the wife? The heirs of the wife are their children, their common children. The husband is also an heir. So kung ikaw, Richard, meron kang asawa, may 100 million kayo, ang kalahati niyan, 50 million, will be your share as a partner. May share ka as a partner. Yung 50 million, dahil nawala na yung spouse mo, yung spouse mo, ang 50 million will now be divided between you and your children. Ngayon, kung yung wife mo merong child, previous marriage, may share din yun. May share din yung child ng wife mo sa previous marriage. Later on, I'll give you an illustration. Because your child in the previous marriage is also your heir. No? You have to remember that hindi lang yung common children ninyo ang heir mo. Yung solo na, halimbawa, meron kang anak pagkabinata, heir mo rin yun. No? So, let us have that. Ito, principle lang ito eh. Ngayon, if your wife or your husband has committed adultery or concubinage, in fact, you have filed a case of legal separation or annulment of marriage, you have the right to disinherit him in your last will and testament. But you can disinherit only for legal grounds. What are the legal grounds? If your wife or your husband has attempted to kill you, he attempted to kill you, you reported to the police, or you wrote it in your diary, in your last will and testament, that wife or husband will be excluded from among the compulsory heirs. Now, but meron siyang share bilang conjugal partner. Kung 100 million ang property ng dalawang conjugal, 50 million will go to the surviving, 50 million will go to the estate of the dead person that will be distributed. So pag dinis-inherit niya yon, ang share lang niya sa 50 million na naiwan, ang mawala ang share ang husband. Pero yung share niya as a conjugal partner will not be lost because of this inheritance. Remember, iba ang partnership sa succession. The husband and the wife are partners. During their marriage, even if only one is working, only one is earning, all the properties that they acquire are conjugal. Except if they sign an antenuptial agreement that everything that the wife earns, sa kanya lang, and everything the husband earns, sa kanya lang. Yan ang ginawa ni Sharon Cunita at ni Senator Kiko Pangilinan. They signed a prenuptial agreement, no? Na kasi maraming property si Sharon pagkadalaga niya at yung during the time of the first husband, no? Ang husband nila may property sila. So to make sure na yung mga property na ma-inherit ng mga anak ni Pangilinan, iba yung property na ma-inherit ni Casey Concepcion, anak ni Gabi Concepcion. No? Anyway, we can use their name because they are public figures. Don't worry about that. And this is just an example. So if you marry twice, be sure na yung property mo sa first marriage must be liquidated first before you go into the second marriage. Kasi pag namatay ka na hindi mo inayos yung property in the first marriage, na magka-mix-mix na yan sa property in the second marriage, doon na mag-aaway yung children of the first marriage versus the children of the second marriage. That happened in the case of Don Sergio Osmeña Sr., who married twice. No? Yung mga anak sa second children, sila ni Sani Osmeña, yung namatay na senador. Tapos ang unang wife, yung sila ni Tomas Osmeña na mayor ng Cebu, yan, apo yan sa unang wife yun. No? So, nagkaroon ng conflict sa property because hindi na ayos yung distribution before the president died. No? So that is what we are. Kayo kung if you married twice, with more reason you must have a last will and testament. Now, if you have an illegitimate child, Richard, are you listening, Richard?
Definitely, sir, but I don't have an illegitimate child.
Assuming like example lang.
Okay.
When you were single, you became in love, and
Okay,
then you have a love child, and then you did not marry the mother, so you married another woman. So you have two set of children, the illegitimate one and the legitimate. Pero remember, yung when the child was conceived, you were single, your girlfriend was single, so ang tawag sa kanya is natural child. Natural child. And then later on, ang kanyang share magiging 1/2 sa share ng legitimate child mo. No? Kasi property ninyo yan sa conjugal partnership ninyo ng wife mo, you have 100 million pesos. Example lang ito, wag na tayong magtipid. Sabihin nyo, sir, sobra ka naman mag-example. Wala namang bayad yung maggawa ka ng example 100 million para madaling i-divide. No? 100 million, kumita si Richard with the wife. So, pag nawala na yung wife, yung 50 million, i-distribute yan ng ang maka-inherit ng 50 million ng wife niya, dalawa lang. Yung anak nila ni Richard, nag-isa, at si Richard. So, ang share ni Richard, magiging 75 million. Bakit? Kasi kalahati yung share niya sa conjugal partnership, that is 50 million. That is as a partner. Later on, pag namatay yung misis, merong 50 million, you divide the 50 million into 2 because both of you are compulsory heirs. You, the husband, plus your son, there are two compulsory heirs. So the 50 million that was for the wife is now divided between the two heirs, the husband and the child. So the child of Richard will not inherit from his wife because hindi sila related eh. 75 million yung nakuha ni Richard ngayon. If Richard dies, that 75 million will be inherited by his illegitimate child. Lalaki pa yung matanggap ng illegitimate child kaysa legitimate. Pero ngayon, pag nawala si Richard, mag-inherit pala ang dalawa na yung children. Ang legitimate at saka illegitimate. Ganon ang mamaya I will illustrate that, no? Now, Richard, if you want your illegitimate child to inherit equal to your legitimate child, you can adopt your own child. Your own child, you can adopt. Sir, can we adopt our own child? Yes, you can adopt your own child. And when you adopt your illegitimate child, he becomes equal to the legitimate. So to increase the testamentary rights or the successional rights of your illegitimate child, you can adopt him. And when you adopt your child, his right becomes equal to the legitimate child. Because an adopted child can inherit from his adopted parents. Pero yung tunay niyang ina, if yung natural biological mother niya, if that mother has a property, he can no longer inherit if he has brothers and sisters. He can only inherit if there is no other heirs. But if he has brother and sister, he is cut off from inheritance because he finds a new mother, the adopted parents. Okay? A widow or a widower, before contracting another marriage, should liquidate first the properties of the first marriage. Yan, I said that already. And then next is when spouses live separately, they are still husband and wife. So in the Philippines today, because of many OFWs, the OFWs sometimes they become in love with other people. The one left behind is in love with the neighbor, and the one who went to Saudi Arabia became in love with another OFW. So their relationship is now problematic. But in the eyes of the law, even if they are separated for 20 years or even beyond, they are still husband and wife. And so the law will still apply. Do not ever ask me, sir, what happens if we have no communication for 30 years and he has already another person, I have already another lover. But in the eyes of the law, you did not annul your marriage. You did not file a judicial proceeding to nullify your marriage. So your marriage is still subsisting in the eyes of the law, even with the lapse of many years. No? If your husband is missing, if you have seen the movie Cast Away, he was stranded in an island for so many years. And then his wife, believing in good faith that he already died. No? But in the Philippines, you cannot do that. You have to go to court and declare and ask the court to declare your husband dead. So the court will publish. If you are still alive, you appear in court 3 times, no, 3 times. 3 hearings, nobody appeared. So the court will now issue an order declaring that your husband is judicially dead. Judicially dead. So if your husband is judicially dead, the entry in the census and statistics will be changed from married to widow. And therefore, you can now get married to another person. Unless you do that, you will be committing bigamy. If you contract a marriage because when your husband or your wife disappeared without you having obtained a judicial declaration of judicial death on the part of your spouse. Now, what happens, Richard, if there are two persons living together as husband and wife, whether they are of the same sex or opposite sex, and they obtain properties? They buy a car, they buy a house, and they are not legally married to each other because they are of the same sex. No? What happens when one dies? And what will happen to the property? Well, according to the Supreme Court, the law of partnership will apply. If 80% of the properties were contributed by one partner and the other 20%, then the sharing will be in the same proportion. So if A and B live together as husband and wife, even if they are not actually married, and A dies, but A was the one who worked very hard, 80%, then the property will go to the heirs of A. If A has no child, it will go to his parent. If he has no parent, it will go to his brother and sister. That is the collateral. No? If he has no brother and sister, it will go to the aunt and the uncle. And if he has none, then it goes to the nephews and niece, and then to the cousin, because the nearer will exclude the farther. If you are a relative with a nearer degree, the farther relative will be excluded. That is the principle. No? Now, if you have found a baby inside the church, no, and you go to the DSWD, and the DSWD will examine you, your way of life, and will go to the protocols of adoption. And now there is going to be a new law on administrative adoption without going through the very expensive judicial proceedings. Then that child will become your child and he will inherit from you just like your legitimate child. When your parents are still alive, you have no right to their properties. So Richard, kung buhay pa ang parents mo, hindi mo pwedeng sabihan, Daddy, huwag mong ipagbili yung lupa mo kasi wala na akong ma-inherit. Sabi mo, who are you? This is my property. You have no right to my property until I die. Your right to my property begins when I am dead. As long as I'm alive, I have the complete control over my property. Except if one half of my property belongs to your mother and your mother is already dead, that means that there is a share in the conjugal and you have a right to that. You have a right because your mother already died, for example. No? To inherit, Richard, kung ikaw, kung something will happen to a person at 7 o'clock in the morning, but before he died at 7 o'clock, a child was born at 3 o'clock in the morning, meaning the birth of the child came before the death of the father, then that child can inherit because he was already a child when the father died. But when the father dies at 7 o'clock in the morning and the child was born at 9 o'clock, that child cannot inherit because she did not exist at the time of the death of the father. See, you have to be already born at the time of the death of the person who owned the property. Now, principle number 19. you can give your wife a gift in your last will and testament. You can say, after giving her the share of her conjugal property, you want to give, for instance, your Mercedes-Benz as my gift to my wife, or my mansion in Forbes Park, I hereby give to my wife, but with a condition that she will not contract marriage in the next 5 years after my death. That is allowed. Ngayon, kung mag-asawa siya, na forfeit niya yung gift, pupunta yan sa ibang heirs. No? Magiging legal succession. Kasi hindi niya tinupad yung kondisyon. Pero hindi mo pwedeng sabihin na forever hindi siya pwedeng mag-asawa. Sinabi mo lang limited lang 5 years. Anyway, by 5 years, edad niya 75, wala nang gustong magpakasal niyan. Pero pag alam na merong mansion, pareho ni Aling Dionisia, baka maraming magpakasal niyan. Oh, di ba Richard? Oh.
Yes, sir, noted.
Tingnan mo si Aling Dionisia, may boyfriend, batang-bata. No?
Yes, sir.
Eh kung hindi yan ina ni Manny Pacquiao. Oh. Pagka may property ka, gaganda ang itsura mo. Tandaan mo yan, Carol. No? Gaganda ka, Carol. Ikaw easy pag may property ka. Pag wala kang property, hindi ka maganda. Yan ang tingin ng mundo. Ang mundo ay mapanghusga. No? Number 20. Ang kondisyon naman, hindi mo pwedeng absolute. Pwede mong sabihin, my wife cannot marry my kumpare, Richard Mamuyak. He can marry anybody else but not Richard. O yun. That is allowed by law. No? So, iwanan na natin yung mga COVID. Punta na tayo talaga sa leksyon natin ngayon kasi let us now define what is a will. Can you read that, Richard?
Sure, Attorney JBJ. Is this the one you on the screen, sir, or the?
Yeah, the screen.
Okay. Will and testament is an act whereby a person is permitted with legal formalities to control the disposition of his estate to a certain extent.
Remember, only to a certain extent. So, you can proceed, Richard, to read that.
Okay, with a legal will, you can do all this and reduce your family's legal costs and potential for disagreements about your wishes. But you need to know what information is included in the last will and testament, parties in a last will and testament, and when do you need legal last will and testament.
Okay, there are two kinds of will and testament, no? So, yung tinawag na holographic will at saka yung notarial will, no? I will skip the other things, no? At the end of this activity tonight, ladies and gentlemen, you will know how to write your own will. I promise you, you will know how to write your will. No. So we need to understand certain basic terms. So can you read the definition, Richard? Decedent is?
Decedent is one who dies without a will. His assets are collectively called estate.
Yan, sa baba.
Testator is one who dies with a will.
So if you have no will, that you are called decedent. If you have a will, you are called testator. No? Okay? So with that, there are two kinds of will. Holographic and notarial. And your property, after you liquidate the conjugal partnership, in other words, you give a share to your wife, husband, then when you have your property, one half of your property will be called legitimate, the other is free portion. So the free portion you can give away to anybody, and the legitimate you have to give to your compulsory heirs. So Richard, if you have 3 children and 1 wife, you have 4 heirs. So your 4 heirs will now divide among themselves the 50 million. 50 million, that is 12.5 million for every year. Your wife will get 12.5, the children will get each 12.5. Now, what happened to the 50 million, which is your free portion? You have a favorite child, Richard. You can give the whole 50 million to one of the children. Nakatanggap na siya ng 12.5, you add the 50 million to him. Now, of course, that will be a cause of major trouble afterwards if you do that, no? Because the other children will contest the will, no? They will allege that you were influenced by that child who was favored in your will, no? So you have to think, but under the law, you are allowed to do that. You can even give that away to the Red Cross, no? You can give away that. You can give that away to the Red Cross, the 50 million, which is the free portion. So here, can you read it, Richard, again? Richard.
Succession is the process of inheriting. Decedent is the owner of the property who dies without a will. A testator is the property owner who dies with a will. Here, our successor is the person inheriting.
Okay. So yan na, paulit-ulit yan. That, please help me, Richard, because I'm losing my voice, no?
Compulsory heirs are designated by law like spouse and children. Instituted heirs are not named by law but chosen by the testator only when he executes a will. Beneficiary or legatee is a person who receives a gift from the testator through a will.
Okay, so if I have a last will and testament, if I put there that one of my cars will be given to my driver who served me for 32 years. My driver served me for 32 years, so I am giving him one vehicle. That driver is called an instituted heir, and he is a beneficiary of a gift that was given to him by the testator, and that is myself, no? Okay, can you help that in reading that, Richard?
Probate of will is a formal proceedings where the court establishes the authenticity of the will. Executor is the person designated by the testator to facilitate the faithful implementation of his will. Administrator is the one appointed by the owner to manage the properties in his behalf and to render regular accounting of his management.
Okay, so if I execute a will, for instance, I have 100 hectares of land in Cebu, and I put in the last will that I appoint Richard Mamuyak as my executor. So when I die, Richard will go to my family, he will read my will, and he will say, I will now go to court and ask the court to approve the will. Is there anybody of you who will object? If there's no objection, the court will now order the distribution of the property according to the wishes of the testator. Now, I will appoint Carol to be the administrator. She will be in charge of paying taxes to make sure that the tenants will give the share from our land, and she will make accounting to the heirs what happened to the property until it is distributed. No, the executor can also be the administrator. So being an executor and administrator can be made on the same person. Now, if you have only simple properties and small properties, you can name one of your children to be the executor. No, If he is the eldest and the others respect him, he can be the executor and the administrator, and he will be in charge of making sure that your will is implemented according to your wishes. No? So, yan. So here the law defines the share of all the legitimes. These are the legitimes. In other words, if you die, you cannot touch this because 1/2 of your property is reserved to your legitimate children. If one of your child died ahead of you, the child of your child is a descendant, will represent his mother or his father in getting the share from 1/2, 1/2 of your entire property. Now, if you do not have children, your legitimate parents, but your widow will always be together with your children or together with your parents. Whether you have a child or not, the widow or the widower will always be a compulsory heir. Remember that, no? You cannot exclude your wife or your husband. He will always be. Oh, who are the compulsory heirs? Oh, this one. Number 1, your legitimate child. Remember how there is a word legitimate. So wala pa yung illegitimate mo, panglima lang na priority yan. Ang unang priority talaga, the first priority according to Article 887 of the Civil Code, your legitimate children, no? Then in the absence of legitimate children, no, in default of number 1, legitimate parents. Remember, it should also be legitimate parents. If one of your parents died, but you have your grandparent, then he will also represent a parent who died. If one of your parents died, the grandparent will represent the parent who died. No? And then number 3, the widow or the widower is always there. No? And if you have an acknowledged natural child, Richard, yung anak mo pagkabinata o pagkadalaga is called acknowledged natural child. Pero yung anak mo na may asawa ka na, nakaanak ka pa, illegitimate child yan. That is really illegitimate. No? So when a person dies with a last will and you have 100 million assets, 50 million. In other words, share mo na ito, 200 million yung conjugal ninyo, na bigyan ka ng share na 100 million. So yung 100 million na yan, 50 million is reserved to your compulsory heirs, namely your wife and your children. The 50 million you can give away to the Boy Scout of the Philippines. No? I always repeat that principle. No, with a last will, and testament, the 100 million will be distributed. No, halimbawa, 50 million is reserved to his compulsory heirs, to his wife and children, and the others to charity, to your barangay, whatever is your wishes. Can your children object? Sabi, why did my father give to the municipality even more than what we receive? That is his right. 1/2 of his property is completely free to dispose, no? And the children has no right to object. No? So without a will, no, what happens? No, without a will, the 100 million will be divided equally. So, ladies and gentlemen, if your husband or your wife dies with a will, there is probability that your share will be lesser because he will give away 1/2 the proportion. But if your husband or your wife died without a will, there is assurance that you, the wife, will have a share equal to the share of one child. No? So if there are 4 children and 1 spouse, there are 5 children, there are 5 heirs. That means that the 100 million will be divided equally among the 5 heirs, 20 million each. So you may ask, what about the conjugal property? Sinabi ko na conjugal property should first be liquidated before the property should be distributed. So the partner will always have 1/2. So if the properties of the husband and wife is 200 million, 100 million will be given to those to the one who died, and 100 million to the one who survived. So the 100 million to the one who died, that is the one that will be distributed by succession. Because when you are still alive, then your property cannot be inherited by your children. Because inheritance comes only when you die. No? So, example, 200 million at the time of the wife's death, we have 4 children. The conjugal partnership of gain shall be liquidated. So 100 million will go to the husband, 100 million will go to the wife. Then the wife died, the husband will have a share to the 100 million together with the children. So they will divide equally among the 5 heirs. So that is the division. So dalawa na ang pera ng husband. Meron na siyang 100 million plus the 20 million that he received as an heir and the 100 million as a partner. Are you following me, Richard?
Definitely, sir.
Okay. So when one of the spouses die, you have to liquidate the property. What do you mean by liquidate? You inventory the property, you pay all the indebtedness, may utang, bayaran, bago i-distribute. Hindi ka pwedeng mag-distribute ng property na hindi mo bayaran ng mga utang. No? Kung wala nang balance, di wala nang ma-divide. So before you start a new relationship, before you enter into another marriage, you have to liquidate all your property relationship with the first wife who died. No, yan, ganun yan. Now, if you go to the second marriage, you bring with you the 120 million. So, si Mr. X, namatay ang asawa, may dala ngayong 120 million. Yung 120 million na yan, ang 100 million was the share as a partner. The 20 million was the heir, a share as an heir. So may 120 million siya. Ngayon, nag-asawa siya ng pangalawang asawa. Nagkaanak sila ng isa sa pangalawang asawa. Then namatay siya. Namatay siya. No? Sinong herederos niya? Ang heirs niya ngayon ay 6. Bakit 6? Meron siyang anak na 4 sa unang asawa at may anak na isa sa pangalawang asawa, and then the second wife is an heir. The second wife plus the child of the second wife, in addition to the 4 children of the first marriage, that they will divide the 120 million equally among themselves. Do you understand that, Richard?
Absolutely, sir.
Okay. So you have to enter into a prenuptial agreement with your second wife. No? Either separate property, you have a property, it's yours. My property, it's mine. We will not mix our property. Because if you do not have a prenuptial agreement, there will be conjugal partnership of gain. even if only one, no, has been earning, that all the earnings during the marriage will be considered conjugal. Anything that you buy after your marriage is conjugal, even if the money used was exclusively owned by one of the spouses. If the children of the first marriage end up inheriting from both parents, remember that the children of the first marriage inherited from their mother. They inherited 20 million. Now later on, with the 120 million brought in by the father, and the father died, they inherited again another 20 million because the 120 million was divided into 6. The second wife was able to inherit from the properties of the husband, equal to the share of the children. All the children, with their first marriage, second marriage, they had equal share. Kaya maging komplikado ang buhay nyo kung mag-asawa kayo ng pangalawa. No? But if the second marriage was more prosperous, meaning, sa first example ko, wala silang kita sa second marriage. But here, the second marriage earned 260 million. So yung 260 million will be divided by the second wife and the estate of the husband as partner. So may 130 million siya. Now, when the husband dies, meron siyang 120 million from the first marriage and the 130 million from the second marriage. So he has 250 million. It will now be divided, no, among the 4 children of the first marriage plus the wife and the child of the second marriage. 250 million divided by 6. Now 41.67 million each. No, remember that the children of the first marriage were able to inherit already from the mother. This is only from the father. So this will happen if there is no will. But if there's a will, the sharing will become different because practically the husband can give all the proportion to the first children of the first marriage, or he can decide to give the proportion to the child of the second marriage. That is the advantage of the will because the husband will have control over the disposition of property. Now, ladies and gentlemen, in the interest of time, I will now go directly to the will itself. No, I will spare you from the very technical aspect to avoid confusing you, because I promise you to be able to write your will. I will now go directly to the holographic will, which is very simple. No, this is. Richard, can you read the definition of a holographic will?
Yes, sir. Holographic will is one handwritten by the testator, dated and signed by him, and does not need any witness nor any notarization.
In other words, tonight you can write your own will. You can use a yellow pad or a bond paper, ball pen in your own handwriting. This is very important. Handwritten, not typewritten. Handwritten. Then there is a date, there is a signature, and it is more than 2 pages or 1 page. You have to put page 1 and page 2. And you don't need a witness. You do not need any administrator or executor. It's up to you, because if you do not name your executor, the court will appoint the executor. So example, later on, Now, let us define notarial will. This is the more difficult one. Can you read it?
Notarial will is one usually prepared by a lawyer for a testator, dated and with pagination, duly acknowledged by the testator and his three witnesses in the presence of one another, and duly notarized.
So remember, when you have many properties and you married many times, you have many heirs, you will write a notarial will. It's very difficult. You need three witnesses. Be sure that the witness will not die ahead of you, because the witness will be cross-examined by the court, and there must be notarization. This is more complicated. So I will now give you an example of a notarial will. Can you read it, Richard?
I'd love to read it, but okay, sir, I'll give it a try. Last will and testament, Estela Laksamana E. Paloma. Upon my death, the following properties of mine shall be distributed as follows. House and lot at number 345 Elizaldo Street, BF Homes Parañaque, to Delphine Marquez. Number 2, house and lot in Poblacion, Sasmuan, Pampanga, to Mark Anthony Marquez. And number 3, jewelries, wardrobe, and Pajero vehicle to Winwin Fernandez, and cash of $500,000 to each of them. Video savings account number 557-549-00210.
BF.
Yeah. Sheila
Oh.
Laksamana, aka Alma Paloma, September 13, 2021.
So that is enough. This is already a valid will. You can do it. You name your heirs, you enumerate your property, and you distribute the property according to your will. No? So hindi sila mag-aaway kung akin yung bahay sa Pampanga, akin yung bahay sa BF Homes, o akin yung Pajero. Meron na, dinistribute na. No? So now, I will make sure that we have 1 hour of question and answer. I want this to be read, no? This is the last will and testament, no? Which is, this is another holographic will, Richard. Please read it.
Okay,
Last
sir.
will.
I will try my best to read it. It's kind of, okay, the one type, sir, is a last will and testament. There's my last will and testament and my list of what I own and who receive it at my death follows. Diamond wedding ring to granddaughter Julie Ham. Ruby ring to my best friend Mary Jones. Gold cross necklace to June, my sister. TV and our furniture, Gary Mack. 2023 Equinox car to my nephew, Robert Carson. Wendy Will signature, dated March 18, 2017.
So that's all. Dated, signed, and there is the name of the property and the name of the beneficiary. That's all. No? The more difficult one is the notarial will. So let us just try to read it, Richard, because this is really an actual will. I changed the name. I changed the name of the person. No?
Okay, I'm loving the font, sir, but let me try it. Okay.
Oh, if some of your assistant can help you, you ask them. Like, is she or is Carol can read it? Whoever. No.
I can do it, sir. I can do it.
Okay.
Okay. Last will and testament of Piolo Martin E. Duterte, September 13, 2021. Know all men by this present. I, Piolo Martin E. Duterte, Filipino of legal age, married and resident of number 77 Paradise Avenue, Forbes Park, Makati City, Metro Manila, Philippines, with a sound and disposing mind and memory, and without having been forced, intimidated, or unduly influenced by anybody, have hereby voluntarily executed
Oh.
and
Continue.
proclaim this instrument to be my last will and testament in English, a language I speak and write, within which I am very well conversant. And I hereby make the following declarations and disposition. That I hereby declare that the following are my compulsory heirs. A, my beloved wife Julia Barreto E. Montes. B, Inigo. C, Bea. D, Daniel. C, Rex. E, Rex. F, Clifford. And G, my acknowledged natural child, Ferdinand Lemuel, with my first girlfriend, Tiffany.
Okay.
That
Next.
I am the sole and absolute owner of the following properties. 3.1 mansion worth 68 million pesos located in Coron, Palawan. Specifies are in Annex A to this will. 3.2.
Specifics are in Annex A to this will.
Okay. 3.2 mansion worth 55 million pesos located in Barangay Boracay, Aklan. Specifies are in Annex B to this will. 3.3 mansion in Dasmariñas Village worth 127 million pesos. Specifies for Annex C to this will.
Okay, continue. Maraming mansion.
Wow. 3.3 mansion in Beverly Hills worth 10 million US dollars. Very specific in Annex D to this will. 3.5 luxury condominium in Manhattan, New York worth 7 million US dollars per specified in Annex E to this will. 3.6 luxury Sorot in South Bay, Geneva Lake worth 5 million euro for specifies in Annex F to this will. 3.7 resort complex in Mactan, Cebu worth 100 million pesos per specifies in Annex G to this will.
O sige pa, maraming property.
3.8 for private planes worth $500 million per specified in Annex H this will. 3.9 3 luxury yachts worth 300 million US dollars per specified in Annex J. 3.10 assorted jewelries deposited in the private vault of undersigned in Burns International Bank, Bern, capital of Switzerland, for inventory in Annex J, all worth 1.75 billion euro. Secret code entrusted to my daughter, Bea.
Okay, we will shorten this because makakalula yung mga property.
Yes, sir.
Sobrang dami,
Yes,
no?
sir. Napapasana all na nga ako, sir.
Pero actually, I was able to make this will for somebody. This is really a true will which yung mga name dito at mga amount ay binabago ko lang, no? I just want to show you that to make a notarial will is a very complicated process because you have to execute an attestation clause, no? Together with your witnesses, 3 witnesses, 3 witnesses, no? At yung 3 witnesses na yan, manunumpa sa harap ng notary public, and then they must be present together, not one by one. And then they have to be present together with you before the notary public. So alam nila ang sikreto mo. And then it will be notarized. And with that, we are finished with the notarial will. Unless you have question or you want to clarify certain things, I'm willing to answer them. And you can start reading from your chat box. And I will now stop share so that I will see the faces of those who want to ask questions.
Okay, thank you so much, Attorney JBJ. Definitely, that's quite an info overload, but definitely very useful, especially in the current situation that we have today. We have some questions in the chat box. So would you like me to call this our attendees so they can personally ask those questions?
Well, let them have the choice whether they want to say it personally or we'll just read from the chat box.
Okay, can I ask you first the question coming from an anonymous attendee before we can read the other question. So this is from one of our attendees. He or she is asking if husband and wife has conjugal property and only one party want to create a will. Is that will still valid? Even if, example, only the wife creates the will and the husband does not sign the will?
Okay. First of all, invalid ang will na husband and wife. In fact, it is required that you do not tell your wife or your husband about your will because a will is a personal act. A will does not have to be known by the spouse or the husband. In fact, if your husband will know the content of your will, it may destroy your relationship or it may hasten your death. No? So you are supposed to keep this secret from your spouse. You don't need the signature of your husband or your wife when you make a will because a will is a personal act of one person.
Oh, okay. I think that Attorney JJ made that clear. So thank you for that answer. I would like to call Miss Celerina Amores. Can you turn on your video so you could? She posted a question, but I think this is deeper. There are other questions that will be a follow-up. Celerina Amores asks, can you adopt your grandchild?
Yes, you can adopt anybody. You can adopt your grandchild because you want your property to go directly to your grandchild, not to go. If you have 100 million pesos, Ma'am Celerina, 100 million, the one half of that property you can adopt your grandchild, and your grandchild, you can give that property to your grandchild without causing it through your child. No? But the other half is reserved to your compulsory heir. And if you have a child, your grandchild is not your compulsory heir. It is your son or your daughter who are your compulsory heirs. So to make sure that your grandchild will get the property, you can adopt your grandchild. Yes, that is allowed by law.
Okay. So for the other attendees or who's posting their question right now, you can also click the raise hand button so we can give you an audio and video.
Si Leo Hilor may question.
Okay. Sir Leo Hilor, would you like to have your video or audio turned on so you could personally ask the question to our dear speaker, Attorney JBJ? He has two very interesting questions actually, so I think there would be some. Okay, so can you give Sir Leo the video and audio spotlight, please?
My God.
Leo.
Sir Leo.
Yes, attorney, Mr. President.
Oh, what is your question?
Good evening. Oh, nasa ano po ako ngayon actually. Nasa Pampanga.
Oh.
Santa Rita. Anyway, yung question po, attorney, no, are the details kasi kanina no, yung examples na nabigay ninyo. Parang general information lang about the property or asset. So ang question ko, are the details of the properties or assets not necessary in the last will? Like for example, yung mga TCP, plate numbers.
Yeah, that is better. The more specific is better, but it's not required. Because yan, pag marami kang property, Leo, you have to really specify. But if you have only one piece of land, you say, I have a piece of land located in Parañaque, in Elizalde Street, meron namang number, that is already specific enough. But yung sa notarial will kanina na binasa ni Richard, merong specifics in Annex A. Doon sa Annex A, nandoon yung Xerox copy ng title, yung mga area, location, boundaries, nandoon yon. Kasi hahaba yung last will mo kung i-describe mo lahat. So i-annex mo na lang, Annex A, specific nandoon sa annexes ng iyong last will. But the annexes, you have also to sign. Ganon yun. Leo.
Okay. Thank you so much, Attorney JB. Another question, no? Kasi you also mentioned na as much as possible, dapat is maganda kung hindi alam nung spouse yung tungkol sa last will and testament. So to whom shall the will be given for safekeeping?
To your executor. To your executor, if your executor or to your meron kang kahadiyero or meron kang something na kung saan mo kinikip yung mga important documents, or better, Leo, bank, merong bank deposit, merong box doon sa bank. Nandoon yung misis ko, yung mga alahas niya, nilalagay niya sa bank, no? So you can keep the documents in the bank with a copy furnished to your executor and to your notary public, so that when something happens, there are 3 people and there are 3 sources of your will.
Okay. Thank you so much, Attorney JBJ.
Oh, CEO, we miss you already. We miss you,
Nice to
Leo.
hear from you, Sir Leo.
Thank you so much. Yeah, see you in
Batangas.
Team Up. Stay safe. Stay safe. Bye.
You too. Okay. So yan, Attorney JBJ, from one of our, actually from former VP, Leo Hildor.
Yeah.
Here's another question. I'd just like to ask Miss Celia Guzman. Would you like to ask the question personally?
Kaibigan natin yan, si Celia.
Miss Celia, Attorney JBJ would like to see you on screen. Maybe you could turn on your video and audio so we can give you the spotlight. Okay. She has one question here. Basically, she posted it regarding holographic. Okay, so we're not getting any response from Miss Celia, so I'm just going to read it, Attorney. There's a holographic will covers only the properties owned by one doing the will.
Yeah, you cannot give away what does not belong to you. In other words, if that property is an exclusive property of your husband, no, and you have an antenuptial agreement of complete separation of property, then you can only give away what belongs to you, no? And for instance, meron kang property that you look forward to inherit from your father. Hindi mo pwedeng i-give away yung buhay pa yung father mo. It's not yet your property. So you cannot include it in your will, no? You can only give away what really belongs to you.
Okay, that's clearly said. I hope you got your answer there, Miss Celia. So we got a couple of questions from Miss Soila Pilola. Ms. Soila, would you like to ask the question directly to Attorney JBJ? Okay. And also for those who has question in mind, you just click the raise hand button. Okay, I think Ms. Soila is...
Hi, Attorney. Good evening.
Okay. Hi.
Good evening, Ms. Soila.
Can you give me an advice? What if my aunt kasi is already a widow? She has this special child and yun lang po yung only heir niya. So what will happen with all the property? Do we need to assign someone, maybe a cousin, to administer all the properties? Like for example, may mga rentals, mga ganun po.
Okay, very good. if the child is a special, and when your auntie goes, no, there must be your auntie if she makes a last will and testament, she has to appoint you or anybody else to be the administrator of the property, because the special child cannot be the administrator. She is not of the capacity, the legal capacity and the mental capacity or physical capacity to administer. So if your auntie fails to make a will, the court will have to appoint an administrator and guardian to the special child, administrator to the property. And then that property will belong to the special child, but the special child cannot avail or use of that property without any person of sound mind and of legal and physical capacity to administer the property, like paying taxes, like receiving rentals from their properties. So you have to advise your auntie to name somebody that will take that responsibility.
Got it. And then until when po yun? May certain duration po ba? Or let's say medyo hindi okay yung nakuhang administrator, pwede pong i-replace?
The other relatives can petition the court to replace the administrator who is squandering the resources or the wealth of the person who died, for instance. You have an interest, no?
Okay. In the event po that the child will pass also, and then who will decide po on about the property?
Very good question. If your auntie has no descendant other than the special child, wala din siyang ascendant, patay ng parents niya.
Yes.
So the collateral, the brothers and the sisters, your parent or your other uncles can inherit those property.
Okay. Well noted. Thank you, attorney.
Okay. Definitely, sir. Pag tayo natututo sa mga personal personal
Maganda
questions.
yung mga tanong because these are very, very practical questions.
Especially if we are also experiencing the same dilemma or we are in the same situation. Attorney, may nag-send sa akin anonymous question to. So even the others can send me a personal message if you don't want to be identified. So for this one, attorney, he is asking if he can assist his mother and father in making or preparing the last will and testament.
Alam nyo, yan ang magiging cause na ang ibang ears ang magrereklamo. Halimbawa, ikaw Richard, kapatid kita. Then yung mother natin ay mahina na ang mata. Tapos ikaw yung nag-assist, no? Ngayon, ang maganda diyang gawin diyan is to prepare a notarial will, hindi holographic. Kasi holographic, hindi na siya makasulat, for instance, in handwriting. So, it is good that the lawyer will be the one to assist, no? Because the lawyer is non-partisan. Pag ikaw ang mag-assist, magdududa na nagbigay dyan ng stipulation that will favor you, no?
Yes.
So,
attorney, even if the parents or the father or the mother is the one who requested that certain child is the one to assist.
yes, but the other children will complain.
Okay.
Buti kung the only child siya or the other children will not complain, no? Okay naman yan, basta walang magreklamo. But kung yung iba nakita nila the distribution is not fair, they will question that as a ground to nullify the will. That's why during the probate, the court will determine whether there is an opposition to the probate of the will. Any person who feels that they are prejudiced or they suffer an injustice, they can file an opposition. No?
Okay. So yan, dyan na nagsisimula yung tinatawag na away pamilya. No? So yun, thank you for that response, Attorney JBJ. We just like to call Miss Clarita Cristobal. She also has 2 questions written in the chat box. So, ma'am, would you like to directly ask the question to Attorney JBJ? Or you just want to let us read it? Okay. Para naman po mapakinggan natin ang boses nyo. Okay. Sige po. Attorney JBJ, ako na lang po yung magbabasa.
Okay.
Ayan na si Miss Clarita. Sige po, Miss Clarita, we can hear you loud and clear.
Okay. Good evening, attorney.
Hi, good evening.
This is my question. What happens if the property is acquired when you are still single? The second question, I forgot na.
Okay. Habang inaalala mo yung second question mo, sasagutin ko yung first question. The property that you acquired when you were single is not a conjugal property. So, when something will happen to you, your husband has no share in the conjugal partnership because that is not a conjugal property. But your husband will have a share as an heir. No. Kung ang property ang worth ng property ng na-acquire mo when you were single is 10 million, kung conjugal sana yan, may 5 million na siya kaagad as share. Pero ngayon wala siyang 5 million. Yung 10 million will be divided how many years? Do you have children? If you have 3 children plus your husband, they will divide the 10 million into 4. No? May share ang husband mo because heir siya. Yan ang heredero. No.
Considered heir siya.
Yes.
Oh my.
Unless you disinherit him. If he has committed a very
Is that
serious
possible?
offense. Huh?
Attorney, is that possible to disinherit?
Yes, I mentioned that in my presentation.
Mm-hmm. So maybe Attorney JBJ, you would like to do a refresher on how to disinherit someone.
I will share the slide on disinheritance. I will go back to the presentation, the slide, no, because there is a process of this inheritance, no, that can be done to disinherit your children or you disinherit your husband, no. That can be done. I will try to look for it, no. Process of this inheritance, no.
Nawala.
We can still hear you. You're still with us, Miss Clarita.
Can you see the slide?
Yes, sir. Yes, sir.
Because there are grounds for it. You know, this course kasi ay
Ayan.
ito. Where you want to disinherit your children, these are the grounds, no? Pero ang kanya disinherit the wife the husband no? Oh yan. Richard, can you read that? Those are the grounds for disinheritance of a spouse under Article 921.
Okay, this is for the question of Miss Clarita and anyone who can relate to the situation. So the grounds for disinheritance of a spouse are as follows. 1, conviction for an attempt against the life of a testator, descendant, or ascendant. Number 2 is when the spouse has accused the testator of a crime punishable by imprisonment of 6 years or more. Third cause can be causing the testator to make or change a will. Then it can also be committing an act justifying legal separation. Another one is to when the spouse was given the cause for loss of parental authority. And lastly, unjustified refusal to support the children or the other spouse.
Oh, okay. So, kung ang husband mo, Miss Clarita, ay nag-attempt against your life, no? And you filed a case and he was found guilty. Very difficult yan. Number one. Number two, kung nag-file siya ng kaso laban sa iyo, accusing you of a crime that is serious. Number three, pag pinilit mo yung husband mo or your wife to make a will, that is a ground to disinherit him. No? Kaya huwag kayo makialam sa husband ninyo and wife nyo to whether to make a will or not, because it will precisely be a ground to disinherit you. Number four, adultery and concubinage. Pang ang husband mo kumuha ng ibang babae, ng bababae ang husband mo o ng lalaki, pwede mo na yung i-disinherit. No? Pero
Mas mabigat po ba yun ng lalaki?
Merong
pareho lang ba yun?
ng lalaki at ng babae, infidelity yan eh. No?
Okay.
Tapos, loss of parental authority. Yung mga accused ka of illegal gambling, na-involved ka sa drugs, maraming mga serious offenses dyan na mawala ka ng parental authority, pwede kang i-disinherit ng wife mo or yung husband mo. Or yung husband mo or your wife mo ayaw magbigay ng support sa anak nyo. Yan ang mga ground.
And of course, Attorney JBJ, this should be proven with evidence, di ba?
Of course.
Ayun po. Miss Clarita, sabi niyo po nakalimutan niyo yung second question niyo. Actually, we're able to see the second question. Ayun. Would you like me to read it, Miss Clarita, on your behalf? The second question. Ito yung second question ni Attorney JBJ ni Miss Clarita. Is there an age required in order to adopt a child for last will purposes?
Well, you cannot adopt a child beyond 18 years of age. Kung ikaw, Richard, magagalit ang misis mo, nag-adopt ka ng anak pero 17 years old or 18 years old. Ba't ka nag-adopt ng sobrang gandang babae, 18 years old? Anong objective mo? No?
Para
kailangan minor yung i-adapt mo. Ka mag-adapt ng mga dalaga o dalagita.
Kahit po busilak yung kalooban mong tulungan, pag-aralin, gawing scholar.
Kalooban mo lang ang busilak.
Okay. Sige
pero
po.
yung kalabasan, hindi busilak.
Nakakatuwa pala ito, Attorney JBJ, mga parang phone-in question para tayo nasa teleradyo, parang gano'n. No?
Okay, ano pang mga tanong dyan? Si Leo Abogado, may tanong ba?
Galing sa galing sa Facebook natin, broadcast, sabi sa inyo, we were reaching other people beyond the Zoom. Actually, galing kay Eder Rene, makikinig siya ngayon.
Si Eder Rene nandyan, maraming lupa yan.
Kaya nga po, through Facebook po siya nanonood. So ang una niyang tanong is, isn't the illegitimate children having equal shares with legitimate ones based on the new family code?
There are two kinds of illegitimate children kasi, Eder Rene. Yung illegitimate child, halimbawa ikaw binata ka, nagkaanak ka ng girlfriend mo. Ngayon, binata ka pa noon ang girlfriend mo, dalaga din. Yung bata na yan, may equal share yan sa legitimate son mo. Pero kung may asawa ka na at doon ka nagkaanak, yan ang 1/2 lang. Kaya yung family code natin, nagdi-distinguish niyan dalawang illegitimate. When you conceive and deliver a child at the time when you have no legal impediment, kasi wala kang asawa, nagkaanak kayo ng girlfriend mo, bugso ng damdamin nyo, ay yan ay natural child. at yung kanyang share equal sa share ng legitimate. Pero pagka spurious child talaga, no? Lalo na may asawa ka, nabuntisan mo yung maid mo. Oh. Ayan ang
Maraming
mga
ganyan. Maraming
kalahati
ganyan,
lang
attorney,
ang
no?
matanggap niyan, kalahati lang.
Oh, may mga ganyang kaso talaga. May follow-up question po si Ideren Henner. He also asked, what are the grounds for objections on the executors?
Ayaw mga executor na convicted of crime involving moral turpitude, hindi pwedeng gawing executor yan. Kung limbawa yan ay na konbikto ng estapa o robbery, bakit mo gawing executor yan? Pero baka ang tanong ni Attorney Agaton Rene na ano ba ang ground para maobjeksyonan mo yung will, no? Ang ground diyan kung halimbawa the person was no longer of sound mind. In other words, na Alzheimer na siya, may Alzheimer na yung tao, wala na sa sarili niyang wisyo, gumawa pa ng will. And that is a ground to nullify the will. No? Pareho kanina, yung husband ka, pagkatapos pinilit mo yung wife mo na gumawa ng will. No? Manalipay yung will na yan. No? Because hindi yan free will niya, hindi yan voluntary act niya that is dictated by another person. Yan ang ground na ang will and testament ni Don Sergio Osmeña na nullify dahil nag-object yung mga anak ng unang asawa dahil yung pangalawang asawa strongly influenced the preparation of the will. The second wife of the president was being suspected of having influenced the way the will would be written by the late President Sergio Osmeña Sr.
Okay. So, thank you, Attorney. Something that we haven't read in any history book. So, ngayon lang natin nalaman yan. Courtesy of Attorney JBJ. Attorney, we have another question coming from Mr. Christopher John Wu. Good evening, Attorney. He said, what can be done if one of the heirs are not cooperative with the process? Thank you.
Well, during the probate of the will, all the heirs will be summoned by the court. Those heirs that are not cooperating may lose their right to inherit. If the court will say, because of lack of cooperation, lack of interest, they are declared to have waived the right to the inheritance, and that portion of the will be deleted, and that property will be distributed from among the others who cooperated.
Okay. Point taken, Attorney JBJ. Ay, may follow-up message siya at Rene. Yung question niya po daw are hypothetical. Salamat po daw, pare. So,
hypothetical, I believe him. No?
Okay. Ito medyo fresh to galing sa ating Facebook din. So medyo, di ba, baka makaka-relate dito kasi maraming pangyayari ito makikita natin sa Facebook. So ito po, Attorney JBJ, coming from Miss Cheat. Hindi ito yung ating past president, sir. Ibang cheat po ito. My mom passed away and didn't have a will. She left our ancestral home and a few small properties divided equally among us 9 children. Can I include in my will that my share be given to my kids, or is it automatic?
Well, you can do that because your mother already died. So when your mother already died, the inheritance from your mother to you has already taken place. So that property belongs to you. If you make a will, making sure that it will go to your child, because if you do not make a will, no, and your husband may you may die ahead of your husband, the distribution of that property may not be in accordance with what you like. So, but if you have a will, your husband will be duty bound to follow that, because that is not a conjugal property. That is a property that you inherited from your parents, that was not purchased out or during the marriage between you and your husband. To make sure that your property will go to your child and that your husband will not touch that property, you can also have that to make sure of that, you can and you should execute a will.
Okay, thank you for that. By the way, that question is from Ms. Chit Castillo, one of the speakers we had in PMAP. Her expertise about mental wellness. Before we proceed,
kailangan natin ang mental wellness kasi sa last will and testament, it is important that the one who wrote the will must be of sound mind. Sound mind, no? That is a requirement, no?
Yeah. Point taken. Attorney JBJ, before we proceed, kindly unshare the slide so we can fully see you on screen. Kasi nakita yan, mas kitang-kitang kagwapuhan niyo po, Attorney JBJ.
Ako.
Attorney JBJ, I can see a few more questions here. This one naman coming from Mr. Eric Nielsen. Do lawyers have a formula that can be used for will so that one can just write in there, have the lawyer sign as witness, and then have it legalized or notarized? Or do you always have to start with a piece of blank paper?
That is correct. The lawyers have forms. We have forms. That is a standard form, just like an affidavit. So you just have to fill it up. If you need more pages, then you can have annexes. So Eric, the answer to your question is yes.
Okay, so para mas mabilis nga naman. Attorney JBJ, may gustong bumati sa'yo. Good evening, Attorney Ninong. Kilala niyo po ba to si Lay Amisola Lim?
Ayan ay taga San Miguel Corporation sa Power yan. Napakatalino na bata yan. Anak yan ng kaibigan ko na si kumpare ko na kasama ko sa San Miguel Corporation. Pagkatapos nung lumipat ako sa Pepsi, sinama ko rin sa Pepsi.
Wow.
Hanggang ngayon, tumutulong pa rin sa akin, napakabait, Bicolano, at yan si Lee ay kaisa sa anak yan na kinasal, ako isa sa mga ninong.
So may tanong siya, attorney. Bukod sa pagbati sa iyo na magandang gabi, the question is, what if an employee died without any will? Can the HR execute the division of his insurance claims to his estranged wife, second wife, and illegitimate child to his past girlfriend? Ba? Sanga-sanga, sir. But definitely, this is something applicable.
Ang daming kanyang buhay na yan, ha?
Oo.
No? So,
makulay.
Walang will, namatay. Tapos, maraming heirs, no? So, they can just come together and they agree, ang tawag noon, extrajudicial settlement. Extrajudicial settlement.
But
Walang
can the
problema
HR do
yan.
it, sir?
Ali, kung magkasundo lahat, if everybody will agree, there's no problem. But the problem there, if some of the heirs are not cooperative, so you will have to go to court. It's better to have extrajudicial because it will not be expensive. Once there is judicial settlement, it will be more expensive. Every party will have a lawyer. It is a very complicated situation, no? Stressful situation.
Definitely, sir. All right, sir. Thank you for that message. Any follow-up questions? Okay, I can see, sir, some anonymous questions. So, yun, siguro mga ano to, asking for a friend. So let's start with the first one that I'll read it now. Good evening, attorney. Married po ako with one daughter, and yung daughter ko, anak ko po siya sa pagdadalaga In short, hindi po yung husband ko yung father nung daughter ko. Pero hiwalay na po kami ng husband ko. Kasi yung property ko is ako lang po ang nagpundar, kahit conjugal property since kasal pa rin kami. Pwede po ba ilagay sa last will and testament ko na daughter ko lang ang mag-inherit ng mga assets ko?
Well, kung hindi mag-object yung husband mo, pero pag nalaman ng husband mo at interesado siya sa property mo, even if you are the only one who worked for it, if you acquired that property during the marriage and the marriage has not been annulled, even if your husband is separated from you, in the eyes of the law, he is still your husband and he will be entitled to 1/2 of your property. If you execute a will giving the entire property to your child or prior to your marriage, then there is a danger that the husband will file a case against your child to recover a portion of that property.
Okay, so Attorney JBJ, the solution is to have the marriage annulled before
Yes.
executing. Okay. So yun po, annulment is the key doon po sa ating...
Pero very expensive ang annulment. Alam mo ngayon, merong bill na pinile si Congressman Edsel Lagman of Albay, First District of Albay, for absolute divorce, which is being opposed by the Catholic Church and many organizations. No?
Yes, sir. Okay. Another one. Medyo dumami po, attorney.
Okay lang.
Gusto nila anonymous question, and definitely we welcome all your question. As soon as we have a question na makikita, go game na game po si Attorney JBJ. Mukhang maraming kape ang kanyang nainom kanina pa. So here's one of the anonymous question is, if I have a last will and testament. Oh, gumagalaw. Dahil lang po. Basahin ko po muna bago po kayo mag-type.
Okay.
Sandali lang po, nag-move po siya kasi may nag-type.
Ano yan? Sa Facebook ba yan?
Sa ano po, sa anti pong chat box. So, okay, I need assistance from the team. I-type nyo na lang sa akin because pag may nagta-type na tumataas yung ano eh. Okay. Ito, if I have a last will and testament, but since our property is a conjugal property, the half of our property will still go to my husband when I died. Correct?
Yes, that is correct.
When let us say I did not put his name in my last will and testament, and I only put the name of my children. Still Attorney JBJ, no? Kahit wala yung pangalan sa last will.
Oo, kahit wala ang pangalan, heir pa rin siya.
Okay, I think that's loud and clear. Sasabihin ko na, annulment is the key if you don't want to have your husband or strange husband to be part of the inheritance. Another one, can I impose conditions in my will? Example, spouse here should not marry, or nabanggit ni attorney yan, or property cannot be sold on my compulsory wills. So attorney, ito na yung tanong ko, meron bang maximum year para hindi mag-asawa yung husband or wife just in case mamatay po yung...
Sinabi lang ng batas is reasonable time. So kung halimbawa ang husband mo, ang age niya ngayon ay 60, then you can say for the next 5 years, I give this property to my husband on the condition that in the next 5 years, he does not contract another marriage. That is valid. Pero pag sinabi mo ng 10 years, wala na ring use yan kasi by that time, ano nang edad niya? 80 na. So, ang kaso niya is illegal possession of dead weapon.
Sige po.
Legal possession of dead weapon na yan eh.
Maging reasonable din naman po tayo. So I think 5 years, can I say it? Ideal year. Okay, sige po.
That is the normal one.
Sige po. Ito po another anonymous question, a question from sent to us anonymously. We are five in a siblings. We are five in a sibling. Four of us already have a family. What will happen to the property of the fifth sibling if they die who is living alone? Who will inherit the property?
Anong who is giving alone?
Sige po, Tagalogin ko. 5 po daw sila magkakapatid, 4 may asawa na. So yung isa, dalaga or binata. Kung mamatay po daw yung binata o dalaga nilang kapatid, ano mangyayari sa kanyang property?
Kung mamatay siya na wala siyang anak, wala siyang descendant, it will go to the parents kung buhay pa yung parents. Pero kung wala na ang parents, sa collateral, and that is the brother and sister. So the 4 of you will divide equally the property of that person who dies without a descendant or an ascendant.
Okay. I hope you got your answer there. Another one, ito hindi na anonymous, from Stephanie Giles. Dalawa yung kanyang question. So unahin ko na to. Good evening, attorney. Would it be more practical for a widow to transfer her property to her children through a deed of sale, even while she is alive? Though we know that it will only be enforced when she is no longer around. This is to avoid paying inheritance taxes, estate taxes, extrajudicial statement, etc.
Well, a deed of sale is okay. But if you have a husband or widow na siya, wala na siyang anak, wala na siyang husband. So you can sell your property to your children, but you know the BIR will be suspicious about the value of the property. Sometimes you undervalue your property to avoid paying the value added tax, no? And you know, when you buy a property and then you buy a property at X amount, you sell it, the difference would be your gain. Then therefore there is capital gains tax dyan. So ang valuation yan at titingnan ng BIR kung whether it is reasonable, because you know, between a mother and a daughter, siyempre hindi yan tataas ang presyo. Actually walang binayad yung daughter dyan, no? Binigay talaga niya yon, ginawa lang deed of sale to avoid inheritance tax. Baka pag avoid mo ng inheritance tax, mas malaki pang ibayad mo doon sa capital gains tax. No?
Ayun. So, sumagot siya. Thank you, attorney. Clear enough po. Attorney, may nagtatanong dito, pwede ka daw bang kuning lawyer?
Marami na ang opportunity, marami nang ako yung gumawa ng last will. Marami na akong nagawang last will. So, ay bigay mo lang yung telephone number ko, pwede kaming mag-usap, no? Kung gusto nilang, ilagay mo lang sa chat box. Anyway, open yung, I am a public person. I can help you if you need some help in the preparation of your will.
Okay, Ishi, kindly type in na lang yung email address na lang siguro ni Attorney JBJ para directly kontakin siya. So, may gusto lang mag-hi sa'yo, Attorney JBJ. Hi, Richard. Please send my regards to Attorney JBJ. I'm listening right now. Miss Annalyn Brillantes.
Oh, how are you, Annalyn?
Ayan, kumusta daw po? So, ayun, yung iba nasagot na natin. So, again, to all our participants via Zoom or Facebook, please type in your question now habang only question pang pwede nating itanong kay Attorney JBJ. Kasi pagka wala na tong Zoom na to, ay, nako, I can't assure you kung free na yun. But definitely, the pre-service that Attorney JBJ is giving not only to PMAP members, anyone who's listening right now is very, very admirable. So, type in nyo na po yung mga question nyo while we still have time. Habang may laman pa pong kape ang tasa ni Attorney JBJ. Ito po, may nagtanong po ulit, pwede po mapag-request ng recording. Attorney, okay bang i-share yung recording natin?
Okay, pwede yan sa YouTube channel ko, mag-subscribe kayo. Nandyan si si board member, member of the board, Ning Adolfo. Si Ning Adolfo,
Hi.
nandyan,
Trusty
kasama
Ning.
natin. Oh.
Ayan po. So,
Maraming property yan si Ning at saka si
ay,
Dr.
oo. Tsaka si Sir Marvin po, definitely.
Marvin, Dr. Marvin.
Dr. Marvin, hello po. Wherever you are listening or watching right now, we hope you're having fun or being informed with all the teachings na sinishare ngayon ni Atty. JBJ. Dinadaanan ko lang po yung chat, baka may ma-miss out akong question. So while doing that, please keep on sending in those questions. Kahit asking for a friend po ilagay nyo. Kahit theoretical po. Definitely.
Ito, may tanong dito, hindi mo nabasa eh.
Saan yan, attorney?
For
Ayan.
those couples without a prenuptial agreement, can the surviving spouse waive his inheritance voluntarily? Yes. You can waive your inheritance. In fact, kami, 8 kami magkapatid, 3 kaming nag-waive. Yung mga medyo maayos naman ang buhay. So, sabi ko sa kapatid ko, hindi na ako tatanggap pa ng share sa mga property ng parents natin. Sumunod naman yung 2. So, 3 kaming nag-waive ng aming right. So, yung 5 lang ang nag-share ng property.
Okay. Napakabait nyo naman po, Atty. JBJ. Baka may ano naman po kayo, mayroon pa kayo ibang property dyan.
Alam mo,
gusto nyo i-waive.
pag malaki ang ari-arian mo, no? Malaki din ang responsibilidad, yung sinatawag for every right there is a corresponding responsibility. Alam mo ako, ang laki ng binabayaran kong tax. Pagkatapos ang lahat ng akita ng lupa nasa mga tenants lang, hindi ako binibigyan ng share. Naririnig ko lang, nagpatimbang sila ng kupra, hindi sila nagre-remit sa akin, bahala na si Lord sa kanila.
Sakto yan, parang ano lang, may naalala ko movie niyan, Spider-Man, yung nga sabi, with great power comes great responsibilities.
Oo, ang sabi ng mayor namin, attorney, ipapreso mo yung mga tenants mo. Sabi ko, paano ko ipapreso yan? Mga pinsan ko yan. Pagka pinapreso ko yan, ako rin ang magbabayad ng bond niyan eh. Ako din ang magpapiansa niyan. So,
baka kayo din ang kuning lawyer, no, sir?
Ako rin ang lawyer. Di ano mangyayari dyan?
Sir, may pumasok na question coming from the Facebook listeners natin. This is from Mr. Uy. Kilala niyo po ito. Rico Resio.
Nako, si Paring Rico.
Yan po. Ito po yung kanyang medyo may klila yung tanong. We 3 siblings, may land kami sa Laguna, yung old house namin para sa youngest brother ko. Pero I plan to renovate that house. What will be the consequences?
How can you renovate that house if that has been given to your brother already?
Baka gusto niya lang pagandahin. In good intention, in good faith.
Pag pinaganda niya yan, ang makinabang niya, yung brother niya. Kasi the house, kung whatever, ano bang paraan, Rico, bakit napunta sa kapatid mo yan? Meron bang will ang parents mo na maibigay sa kapatid mo? No? Kasi kung hindi pa yan na divide ang property niyo, wala pang visa at hindi pa ang titulo, the title does not belong. It is not in the name of your brother. So, effectively, that is still a common property to be divided among the 3 of you.
Okay. So yun po, Sir Rico, I hope you got your answer there. But kahit in good intention and good faith, parang singbait niya, Atty. JBJ, gusto niya lang ayusin with no nothing in mind that I would like to have a share. Talagang
Di maganda. Nobody will object.
Yeah, that's good. Attorney, may follow-up question si Christopher John Yu. Sabi niya rito, follow-up question, can a surviving spouse be disinherited because of negligence when his wife was still alive?
That means the husband was the husband was negligent.
Mhm.
Uh, we have read the grounds, no?
Yeah.
Di ba? Merong ground doon na refusal to support.
Okay. It will fall under there.
Yan, doon. Yun ang baging basis dyan.
Okay, so yun po. Christopher, definitely pwede yung mangyari. Meron pa pong isa naman galing sa Facebook natin. Itago daw natin yung kanyang pangalan. So, I won't mention her name. What if magkaiba daw ang will ng husband and wife? Example, yung car sa will ng wife bibigay sa panganay. Pero ang gusto ng husband sa bunso mapunta. Tapos sabay namatay. Kanino mapunta yung kotse daw?
Alam nyo, ang kotse is a common property.
Okay.
Conjugal yun.
Mhm.
So, paano mo ngayon i-dispose yan in your will if it is not your exclusive property?
Mhm.
So, pareho silang walang karapatan yan. No? Pareho sila, yung will nila, insofar as the car is concerned, walang effect yan. No? So,
Okay.
kung hindi makasundo yung mga anak, ilan bang naiwang anak? Bunso lang at panganay.
Bunso at
no?
panganay, yun na. Namatay pareho yung parents sabay. So, kanino daw mapupunta?
Alam mo, ito ha, Richard,
Mm.
huwag mong sabihin sabay. Kasi pag namatay ka, sinasabi ng doktor, time of death, 11:05. 11:05.
Mhm.
Tapos yung isa, time of death, 11:06.
Mhm.
In other words, Richard, kung naunang namatay ang husband,
Mhm.
ang property niya na inherit ng wife. Oo.
Okay.
Pagkatapos, yung kung ang wife merong anak sa unang niyang relasyon, makaka-inherit doon, no? Pero pag
Kahit
nauna,
segundo lang yung pagitan, ha?
kaya very important yung exact time of death.
Yeah. So, hindi pala
At
pwedeng
saka yung
iksatay.
sa
Hindi pala pwedeng iksatay, no?
birth certificate, exact time of birth.
Okay, noted. Ayan, hindi natin nalalaman yan. Definitely, Attorney JBJ made it clear na kahit segundo yan o minuto yan, it's very, critical to take note, especially pagka mana-mana yung pag-uusapan. May additional info pala, Attorney, si Sir Rico Resio, na wala pa palang titulo yung bahay ngayon. Nasa pangalan pa ng nanay nila. So, mukhang buhay pa yata yung mom nila.
Pwede pa yan, Rico, na hindi mapunta sa bunso ninyo.
Okay. Ayun, so I think we have, ito may bagong pasok po. Another anonymous question. What if in a deed of sale of a property value divided equally among the 6 siblings, one sibling does not want to sign? Is there a principle where the majority prevails? 5 versus 1? Pwede ba yung attorney?
In other words, common property yun. Common.
Mhm.
So, namatay na siguro yung original owner niyan.
Mhm.
Pagkatapos ay buong property. Alam niyo ang gagawin diyan? Gagawa yan ng ipasurvey yan at i-divide yan into 6.
Okay.
Then, yung buyer niyan, kawawa yung buyer kung bibiliin niya yung buo at merong isang nag-object. Kasi yung isang nag-object, meron talaga siyang right as to the 1/6 of the property.
Yeah.
So only that deed of sale will only cover, hindi pwede yung the rule of the majority. Hindi majority rule yan. Ang bawat isa may right to determine, ayaw ko ipagbili yung akin. O di siya yung owner, i-divide mo yung property, ihati mo yan into 6, then yung share niya ang maiiwan sa kanya.
Sir, paano po daw kung yung property is bahay? Ayun, may follow-up question. Mahirap hatiin niya tayo, no? Sa 6 yung bahay. So, hanggang kwarto ka lang ng hanggang kusina ka lang, parang mahirap. Either they sell it or I don't know. Ano
Ngayon,
po ba yung advice nyo?
kung ako naman ang buyer niyan, hindi ako bibili. Kasi alam mo ang mangyari diyan, guguluhin ako ng guguluhin nung hindi pumirma.
Nung isang yan, okay.
Oo, nako, pagka common property, mahirap yun.
Yeah.
Nangyari na yan sa lola ko eh. After 20 years, bumalik yung isang anak na hindi daw siya nakapirma.
Okay.
Sabi ng lola ko, bakit kailangan ang pirma mo? Ang nagbenta sa akin yung parents mo. Hindi naman yung mga kapatid mo ang nagbenta eh. Yung parents mo. Buhay pa ang parents mo. Hindi mo pa property yun. So, doon ka kumuha ng share doon sa mga kapatid mo. Kung naubos na ng parent mo yung pera na pinagbilhan, at the time when I bought the property, the owner was still alive. So the children have no right. No? Kahit hindi siya pumirma, hindi ikaw Richard, buhay pa yung parents mo, pinagbili yung lupa, you do not have to sign. That's not your property. That's the property of your parents. Pero ang problema dyan, sa question niya yan, patay na yung parents. So yung bahay ngayon, ibebenta ng 5, ayaw yung pang-anim.
Isa. Opo. So medyo komplikado nga. So the best way siguro is to find ways kung paano masuyo yung isang yun. Total, magkakapatid naman sila. Baka, ba?
Basta ako, kung ako
Malambing.
ang buyer niyan, magwi-withdraw ako. Hindi ko na bibilhin yan.
Oo nga, sir. But definitely, hopefully, masettle yan. Of course, magkakapatid naman kayo. In some point in time, you'll have to agree or definitely you'll come into terms. Okay, so Attorney JBJ, time check, it's 9:27. So ang pangako natin until 10 p.m. Pero definitely kung wala na tayong questions na matatanggap, we can end early. But of course, sabi nga namin, ibato nyo lang or just shoot in your questions at chat box. And we're glad to answer all these questions. Ayan, may isang pumasok po. Yan, medyo dahan-dahan siguro pinag-iisipan pa nila, attorney. Ito daw, paano kung may bahay at lupa ka pero walang titulo? So legally, hindi ikaw yung may-ari. Pero pwede ba ipamana ang rights lang? Uso nga yan, attorney. Or pwede bang ilagay sa will yon para hindi mag-away-away ang mga...
Okay, alam nyo, I want to correct your belief. Even if you do not have the title of the land, you have the tax declaration.
Yan.
Ang tax declaration, you have been paying taxes over the land. You are occupying the land. Nobody is disturbing you in your position. So, you can have it surveyed. Madali lang namang magpatitulo, magpa-survey ka, lagyan ng mga boundaries, then lagyan mo ng fence para ma-establish yung boundary, then magpatitulo ka, gagastos ka lang. But kahit walang titulo does not mean that you do not own the land. You can also execute a last will even if it is only tax declaration.
Okay. Well said, Attorney JBJ. So ito, na-message si Rusty Ning Adolfo. Salamat po daw sa mga learnings. Labor Guru, Attorney JBJ, mabuhay po kayo.
Ngayon, hindi lang labor ngayon kasi ito property na ito, hindi lang labor. No? Nasa civil case na tayo ngayon, hindi lang labor.
Ano pa kaya yung next topics
Ning.
natin? Ano pa yung next topic natin?
Ang Merck ay gagawa ng gamot para sa COVID. No? Yan si Ning Adolfo ang country HR manager dyan. No? Kaya yan si Ning, simple lang yan si Ning ha. Dapat magpresidente na ng PMAP yan si Ning.
Ayun po, ayun, trust Ning, may message sa Attorney JBJ. Regards din daw po, sabi ni Dr. Marvin. So I think we have covered all the questions sent in by our listener and watcher, but definitely this is not the last time that we'll be seeing Attorney JBJ kasi marami tayong programa na kasama siya. At this month and next month, dapat abangan niyo yung mga announcement namin sa PMAP official Facebook. Attorney JBJ, before we come to an end, I would like to present to you a certificate of appreciation. So the Asian Institute of Human Resource Management awards the certificate of appreciation to Attorney Josepos B. Jimenez, DPM, in recognition of his valuable contribution as speaker during the learning session, How to Prepare Your Last Will and Testament, held on October 21, 2021, 7 p.m. to 10 p.m., and signed by AIHRM President Lucila C. Tariela, DPM, and PMAP Executive Director Rene Jimenez, DPM.
Pareho kong kumari at kumpari yan eh.
Yan. At
Oy,
nakikinig sila.
Richard, yung lahat ng mga certificate na binigay mo sa akin, gawan mo naman ng hard copy. Puro na lang ganun. Paano kung makakuha niyan?
Sa
Yun
Lunes,
lang
sir. Pupunta
yun
ako
lang
ng...
ang ipa-inherit ko sa mga anak ko eh.
Ay. Oo, maano yan. Talagang they will see your legacy. Definitely, they'll be proud to held on to those
Nagulat
things.
ako doon sa signatory. Akala ko napalitan na yung presidente ng PMAP, no?
Sa AIHRM president po, si Ma'am Lucy
Akala
po.
ko nagbago na ng presidente.
So Attorney JBJ, definitely we had quite a lot of information na natanggap sa inyo this evening, and hopefully we'll have another session. Oy, may humabol pa po. Pwede pa po ba daw?
Sige.
Ito po, paano kung may bahay at lupa? Ito, nabasa na po. Nag-thank you lang pala, sir. Thank you very much po. Ito yung kanyang lupa
Okay.
daw, rights lang. Nag-thank you lang pala.
Hmm.
Sige po. Okay, so again, we're really glad to have this session to not only for the PMAP membership, but to all the members of the HR community. And we do hope na bukod dito sa ating webinar, umattend din po tayo ng ating mga session kay paid or not, especially next week po. Part of the 65th anniversary of PMAP, yung celebration natin, marami po tayong free learning session. So meron po tayong 65th anniversary summit happening on the 27th of October. So our announcement are posted in the PMAP Facebook official page. So kindly check the details and we hope to see you there. Attorney JBJ, last message to our listeners and viewers for this session.
So thank you for your cooperation, and I appreciate your coming tonight. I hope that I was able to clarify certain cobwebs of doubts in your minds. And in the event that you still have question, you can follow me and you can subscribe to my YouTube channel. You just look for Yusek JBJ, and you can have all the video, including the one tonight. If you need some help about decisions on hiring, firing, transferring, promoting, discipline, laying down of policy, compensation, rewards, hiring, and unions, collective bargaining, deadlocks, strikes, and all these matters, you can access the YouTube channel, and they have the solutions. They are the solutions looking for a problem. Thank you, and good night to all of you.
Okay, that's it. So hope to see you in our next PMAP event. Good evening, everyone, and keep safe. Bye, everyone.
Salamat, Richard.
Salamat, Attorney JBJ.